Thank you, my Lord, for the time. I'll be very brief. My Lord, my submissions will address the possibility that the court may deem it necessary to enjoin the applicants as interested parties to the petition. And my Lord, these submissions are born out of the DCI's prayer number 1, which appears a bit vague and couched in very general terms, that the applicant stroke intended fifth respondent be joined as a party, and then in addition as the fifth respondent to this suit. And also, my Lord, on the recognition that under Rule 7, Sub-Rule 2 of the Mutunga Rules, my Lord has the discretion to enjoin any party as an interested party in the proceedings before you without an application for that purpose. And so whereas the DPP may have asserted that it does not wish to be enjoined as an interested party, we thought it wise to address you on that question and to impress upon you our considered view that even as interested parties, the applicants have not demonstrated that they are necessary for the effectual, just, and expeditious disposal of this matter. My Lord, I'll quickly run you through the principles that are to be considered in admitting a party as an interested party to proceedings. And the first, my Lord, is that an interested party must have a stake in the proceedings. He or she must be affected by the decision of the court when it is made. And my Lord, he or she must feel that his or her interest will not be well articulated unless he himself or she herself appears in the proceedings. My Lord, my understanding of that principle is that the interest to be demonstrated, or the stake to be demonstrated, must be a positive and personal interest. It must be personal to the applicant himself. And it cannot be enough to stake that interest on happenings or on interests that are beyond those of the applicant. And we shall shortly demonstrate why the interest, if any, that has been alleged or claimed by the applicants are not positive and are couched in negative terms and therefore do not meet the test of sufficient interest. For that submission of principle, my Lord, we rely on the decision of Trusted Society of Human Rights Alliance versus Mumo Matemu and 5 others. The Supreme Court decision, 2015, EKLR. For your ease of reference, my Lord, that principle is stated at page 95. Secondly, my Lord,
At?
page 95, page 95.
Page 95 of what?
Of the decision. Of the decision, it's of our list and bundle of authorities. I beg your pardon. Our list and bundle of authorities. The second principle, my Lord, is that the applicant will not be added as an interested party if he has no relief that he is seeking, if there is no relief that is being sought by the substantive petitioner against him. Differently put, my Lord, if the petitioner has no cause of action against the applicant, then the applicant has no business in the proceedings commenced by a petitioner.
Yes.
In the Mumo Matemu case, my Lord, the Supreme Court couched it in different terms. At paragraph 24 of that decision, it held that a suit in court is a solemn process owned solely by the parties.
Repeat again.
The Supreme Court couched it in different terms under in paragraph 24 of that decision, holding that a suit in court is a solemn process that is owned solely by the parties. And so where no cause of action is disclosed against a party seeking to be enjoined as an interested party, enjoining such a party would merely convolute the proceedings and disturb the solemnity of the proceedings of such a party, particularly in a case such as this where the petitioner seeks...
Can you repeat again? Can you repeat again, Mr. Awele? Where there is no cause of action?
Against
where no cause of action is disclosed
is
by a
disclosed
party?
by a party, an applicant
Yes.
seeking to be enjoined as an interested party,
Yes.
then the court must protect the solemnity of the proceedings,
Yes.
or the disorder that may be occasioned by enjoining such a party. For that principle, my lord,
Yes.
we rely on the decision of Joseph Njau versus Robert Maina Chege and 3 others, civil case number 136 of 2000. And on the last principle, my lord, the interest must be clearly identifiable and must be proximate enough to stand apart from anything that is merely peripheral.
Proximate enough to stand apart from?
Anything that is merely peripheral. To make out this principle, my lord, a party must be able to demonstrate in its application and submissions what its interests are, and in so doing, my lord, the court is then given the opportunity to determine, based on the evidence emanating from the application itself and submissions by an applicant, whether the party is indeed a necessary party to the proceedings,
Yes.
and whether anything that it seeks to say or any submissions that it seeks to make in the proceedings can be made by the existing party to the proceedings. Now, my lord, applied to this application, it is my submission that the application fails to meet any of those principles or tests for the following 3 reasons only.
We lost internet again. We lost internet again. Start afresh.
My lord,
Applied to
to these proceedings, we submit that the application or the applications fail to meet the test for admission as interested parties for the following 3 reasons only. First, my lord,
Yes.
the petition before you challenges the decision, the 2 decisions. The petition challenges 2 decisions. One is a decision by the first respondent, the decision by the first respondent made on 8th of July 2019.
Made on?
The 8th of July 2019.
Yes.
That decision was made by the Judicial Service Commission, in which none of the applicants is a member.
Sorry, we're gone.
My lord, did you hear
We're
my last submission?
it's off. We're off. We are off.
What is it? My lord, did you hear my submission?
We lost internet.
Yes.
Yes. The second decision, my lord, is that dated 13th of August 2020.
The second,
Decision is made, is the one dated 13th of August 2020.
yes.
Ex facie, my lord,
Made by?
made by the Judicial Service Commission again.
Yes.
And so ex facie, sufficient basis has been provided for why the petitioner felt that
Yes.
the Judicial Service Commission and the 2 respondents are the only necessary and proper parties for the grievances that she has. Secondly, my lord, and I'm concluding,
Yes.
the applications have not and do not even attempt to demonstrate any positive or personal interest legal or otherwise, for why the applicants seek joinder or to be enjoined in these proceedings. Instead, my lord, the only reasons that have been advanced by the applicants clearly show that the interest or their interest
Yes.
is essentially for the vacation of the stay orders that were granted, and other extraneous considerations extraneous political considerations, if I may, that are beyond your purview, and which have no rational connection whatsoever with the petition before you. Thirdly, and finally, my Lord,
Yes.
the applications evince the intention by the applicants to basically
Yes.
come on board for the purposes
Yes.
of merely supporting the positions already advanced by the respondents and which,
Yes.
all circumstances considered, it is only the respondents who, in any event, would be best placed to effectually, competently, and efficiently advance. And so, my Lord, as you consider those applications, I invite you to very seriously anticipate the ramifications of enjoining the applicants to these proceedings against the petition or the issues raised in the petition, and in particular, the petitioner's grievance as to the blood dichotomy between the respondents and the interested parties. Because that is the main reason why we are before you. The risk that you run in enjoining the applicants to these proceedings is to convolute that dichotomy further, and therefore dilute the petitioner's confidence in the impartiality or fairness of the Judicial Service Commission. And that is the mainstay of the petition. And so, my Lord, that is a very critical issue that you have to anticipate if you are to fairly and completely and finally determine the issues in controversy before you. So for those reasons, my Lord, it is our very, very humble application, or prayer rather, that you dismiss the two applications with costs to the petitioner. That will be all, my lord.